It gives me huge pleasure to come back to UC on this very important occasion. I remember this building at the time it was a hospital. I remember at the time when it was first converted. I think I have talked here before, and I'm very glad that tonight we're going to hear a very important lecture from somebody who I admire very much, who has been a courageous, and I emphasize the word courageous, fighter for the rights of children. And it is very appropriate that he should be doing so under the banner of the Hamlyn Lectures. I'm not the only previous lecturer who is here tonight, and I think probably you all know that Miss Hamlyn, when she came to retire many years ago and gave her modest request to establish the trust, so that you and I emphasize the words you and I, because it was the intention that for common people like us would receive the benefit of knowing the virtues of our legal system. And since she did that, a whole series of distinguished lawyers, both academic, practitioners, and even from time to time, judges have been called on to give the lectures. And the first judge to be called on in 1949 was no less a person than the late Lord Denning. 40 years later, I earned the privilege, I put it down to one of the big mistakes of the Hamlyn trustees, of being invited to give another lecture. And I took Lord Denning's lecture, and I suggested that it could be the background for great developments in our law, and particularly in our public law. And things like declarations might be granted, which was a novelty within this jurisdiction at that time. And above all, I emphasized the need for judicial review. But in all the history of the Hamlyn Lectures, so far as I'm aware, no one has tackled the important subject until tonight of the rights of children. And I don't think there could be any more appropriate subject for us to hear about tonight than the rights of children, under the banner, of course, of the 300th, sorry, very big mistake, 600th anniversary of Magna Carta.
800th.
800, I can't count. 800th anniversary of Magna Carta, of which I'm ashamed to say, at one time I was chairman of the trustees. But the sort of mistake I made, Michael Freeman, and indeed a distinguished line of lecturers, would never make. And it is, therefore, a particular joy that I introduce Michael Freeman's lecture tonight. We are very lucky to be able to hear the third lecture, because, as you know, it was one of the distinguishing features of the Hamlyn Lectures that you don't only have to give one, you have to give a series of lectures. And so, appropriately, Michael started off, first of all, dealing with the historic development of children's rights, which the judiciary, from time to time, played a role. I won't say whether it's positive or negative, because quite frankly, I don't know what the lecturer is going to say about that, if anything. Then in the second lecture, he dealt with very much the position as it is today. And I say we are privileged because this evening Michael's going to look ahead to the future and talk about future rights. And when we are in this country are at a time when the intervention of government may be dramatic in the case of human rights. Just how dramatic we do not know yet, since we are only promised a consultation paper and no consultation paper has been issued, never mind a bill to show the precise nature of what has been going to be offered. But one hopes that Magna Carta in the future will work its magic, the magic which has been influential around the globe, particularly in the case of children. There can't be anything more important, both from our domestic point of view and the international point of view, as our televisions tell us when we switch them on and we see the plight of refugees seeking to come to Europe or elsewhere. And so to hear about rights from someone who is acknowledged as a great authority, if not the greatest authority on his subject, a subject which I would suggest he's made his own, there could be no more appropriate subject or appropriate time for his talk. Now, just before we start, I think one or two people are going to sit down, so we'll let them do so. So, without more ado, because I am sure you all know about Michael's distinguished career. Many of you may have been taught with by him. Many others may have shared the common room for staff at UC, as I did for a short time in my career. Indeed, one reason I always had a special soft spot for Michael was his room in UC was the most untidy room of anyone I've met. It was even more untidy than my own. That's why I have that special affection for Michael. But if you were able to get into his room, what you would hear from him if you needed help was, first of all, the fact that he would take seriously your request for help, and secondly, words of wisdom expressed magnificently. So, without any more ado, I'm going to call upon you, Michael, to tell us your lecture.
Well, it's always a great pleasure to be introduced by you, Lord Wolf, and thank you very much for that introduction. I ought to say that one of the most important cases in this country on children's rights, many of you will know, is the Gillick case. And Lord Wolf was in fact the first instance judge in Gillick, got it right, was reversed by the Court of Appeal, who then reversed the House of Lords then reversed the Court of Appeal. So in effect, his decision was the one which ultimately stood. Mrs. Gillick didn't understand that. She said, I had 5 judges in my favour and 4 against. No understanding whatsoever of the hierarchy of courts. In giving the lecture, and in fact the book which is being published as a result of it, the title, A Magna Carta for Children, I'm not to be taken too literally. They did things differently 800 years ago. I'm not advocating that we drag David Cameron or Michael Gove to Runnymede Meadows, leading them beside the still waters of the Thames, or that we draw up a new code for children in Latin, in which Gove, we must presume, is proficient. Anything more top-bottom would be difficult to imagine. Magna Carta, as many of you will know, was first drawn up in Latin, subsequently in French, and English text was produced long after 1215. Invariably described as containing quintessential British values, it reflects rather the interests of Norman aristocracy. Runnymede is described in the Charter as between Windsor and Staines. Today, with much more appetite to locate it in terms of its proximity to Heathrow, being on the direct flight path leaving the airport, any negotiation that would be had, you wouldn't be able to distinguish one of those three languages from the other. They'd be drowned out by the high decibel sound of the aircraft. Little of Magna Carta remains, and only a couple of clauses are of relevance today. Those were described by Lord Bingham as sacrosanct a few years ago. But they contain the building blocks, of course, of the rule of law society. But children do not feature prominently in the Magna Carta. They're relevant only as heirs to property and little else. In the 800 years since Runnymede, Magna Carta has proved very influential. Its doctrines have spread far and wide, and new groups have sought access to its provisions. For example, women, black people, Nelson Mandela, for example, trade unionists, dissidents everywhere, but not apparently children. For those of you who went to the anniversary exhibition in the British Library in the year which is just coming to a close, you will have seen a wonderful exhibition on Magna Carta. But it only featured children as learners. In terms that I've been using in these lectures, they were becomings rather than beings. It didn't show how Magna Carta could be used as a resource by children. The otherwise excellent exhibition guide is similarly remiss. It found room for 1066 and all that. Seller and Yateman describe Magna Carta there as a good thing. And it found space for Tony Hancock, for those who remember Tony Hancock, the famous Tony Hancock script in which he asked, "Did she die in vain?" But there was none found for children as agents or as participants or advocates for their own rights. There were none, for example, for school strikes. And there have been school strikes in this country. A famous one was in 1911, started in Hull, spread from other parts of the country. There was children downed tools and marched through the streets protesting against the cane. You would not be surprised to hear that it was unsuccessful, and quite a lot of caning was done when they got back. Magna Carta has 62 clauses, and I have no intention of matching its lengths. What follows in this lecture will be local rather than global, and top-down inevitably, because I haven't got children here, except my 5-month-old granddaughter, who represents the common people of England for this purpose of this lecture. You can tell Miss Hamlyn that. She may be the youngest person ever to have attended a Hamlyn lecture. And she'll be examined on it afterwards. What follows is inevitably top-down, although much of my argument, although it won't come out in this lecture, would be how important it is to discover what children want their rights to be. And clearly one has to believe in a global story rather than a local story, but for the purpose of this lecture, it has to be tied down to a local one. So much of what I will say will be endorsed by advocates in both the developed and the undeveloped world, the global north and the global south, and indeed by children. But inevitably, I'm going to be concentrating as much on England as anything else. I hope, however limited what I say is, it offers space for dialogue and debate. So let me start with one of the most important provisions in the United Nations Convention on the Rights of the Child. Since people won't have been at these previous lectures, let me just fill you in very briefly. The Convention on the Rights of the Child dates from 1989, so it's 26 years old. It can be broken down for pedagogical considerations, though for no other real reasons, into protection, provision and participation. And I want to talk initially today about participation. In many ways, participation was the most important consideration in the Convention of 1989 because it recognised that children were agents, were capable of addressing their own lives and addressing issues about their own lives and could play a part in decision making. What one needs to do, I think, is to take each provision in the Convention, and I obviously can't take very many of them, and show how we need to get beyond them, to go further than was the case last time, in 1989 that is. One of the points I was trying to hammer home last week was that we shouldn't see the Convention as the final victory for children. We shouldn't see it as the end product so that we don't have to consider it any further, criticise it or try and make it any better. It's very tempting to chorus hallelujah at the end and to say we've done a wonderful job. It's a wonderful accomplishment. And it was a wonderful accomplishment. It's what we had long been aiming for and what we achieved. But there are dangers in foreclosing critique. To get as far as we have, it's been necessary to challenge the status quo. For example, to show that children were beings and not belongings, not becomings. But having achieved this, we must ask, what are the implications of recognising it? It's easy to rest on our laurels and to accept the Convention as the new status quo. I use the analogy of Beethoven, whose first foray into symphonic writing broke new ground, but that didn't stop him subsequently writing the Eroica and ultimately the choral symphonies. So in acknowledging that the Convention is a landmark in the history of childhood, just as in its day, 800 years ago, Magna Carta was a milestone on the way to democracy, but we needed to go a lot further than Magna Carta to get democracy. Indeed, we're only part of the way there now. And progress after Magna Carta was, of course, quite slow. All the rights we have in this country we've had to fight for. None of them were given without a struggle. Think of women's suffrage or the right of workers to organise collectively. There is some irony in what I'm saying now, because the only people who've had rights without fighting for them are children. It was enlightened adults who fought to get the Convention, not children. So children now have Article 12. They now have this right to participate in decision making. Early on, when I wrote about the Convention, I described this article as the linchpin of the Convention. And so it is. It's very significant. It stimulated a huge volume of research, and much of the research is valuable. We've got greater insight into children's abilities today than we've ever had before. We know what they think of work, school, their parents' divorce, corporal punishment, the rights of children. We've got insights into what they think about more or less everything. Childhood studies have sharpened our understanding of the agency of children, made us appreciate that it's a social construction. A branch of childhood studies, child psychology, has enlightened us about development. Another branch of children's studies, children's geographies, has shown us how children participate in changing the nature of their social space. Children's rights scholarship, by contrast, certainly until recently, remained firmly moored to the safe ground of positive legal analysis. We need to think about moving from participation to citizenship. And if he thinks my room is untidy, My notes are even more untidy. For my next trick. I bet a Hamlyn lecturer hasn't fallen over in one of these lectures before. If we take, then, Article 12 as a test case, there's a general agreement that it constitutes the most significant innovation in the Convention. But a careful examination of Article 12 reveals that it's not all that it's taken for. Let me just go through it carefully with you. It says that states shall assure to the child who is capable of forming his or her views the right to express those views freely in all matters affecting the child, the views of the child being given due weight in accordance with the age and maturity of the child. We're told that this gives children the right to participate. Even I loosely once claimed autonomy. But this is far from the truth. First, note, before Article 12 can take off, the child must have been assessed, presumably by adults, as capable of forming his or her own views. Secondly, adults must allow the child to express views, but only where the adults are of the opinion that the matter in question affects the child. Thirdly, these views are to be given the weight that adults believe they should have. This will be calibrated on an assessment of the child's development and maturity. The assessment also being undertaken by adults. A similar process is used when assessment is undertaken by a court in England to determine whether the child is getting competent or not. And as an aside, I say, although people often get it wrong, we don't have a Children's Act in this country. We have a Children Act. A Children's Act would be an act for children. A Children Act is an act about children. And that is reflected, I think, in what I've said about Article 12. I've made the point often, and I'll make it again here today, that children played no part in drafting of the Convention. Negotiating states were represented by adults. Children were excluded from what has been called the social practice of active citizenship. Does that mean that participation is just a sham? Well, certain writers on the subject have come quite close to saying this. For example, Brian Milne said that child participation tends to be a distraction and to move the issue away from citizenship. The contemporary pro-child participation view tends to suggest separatism. Accordingly, children generally make decisions addressing the issues of children and are allowed to have a degree of opinion but no real political influence. So I ask the question, has the time come to transcend participation and to move towards the recognition of children as citizens? Should we be talking about a move from participation to citizenship? Children, of course, are citizens from birth, if not before. Honora O'Neill, one of the most articulate thinkers about children's rights, though a critic of them, will be remembered by those who've studied children's rights as someone who could not conceive of a growth of children's movements. And I've been very critical of that at various times. I remember, for example, when I was in Chile, I witnessed huge demonstrations by secondary school students demanding the right to work and rights in work. This can in no way fit in with Article 12's participatory rights. These demonstrations expose the inequalities afflicting Chilean society in the wake of the macroeconomic achievements and existing spaces of freedom. The massive group of secondary school students managed to raise awareness and show the unrest which had grown during the years of transition from Pinochet to democracy. There are many examples of this in the recent past, and of course in history as well. Does this mean that the Convention lacks legitimacy amongst children? Habermas certainly thinks so. He wrote of the idea of self-regulation by citizens, requiring that those subject to law as its addressees at the same time understand themselves as authors of law. This has its roots, I should say, in a fictional social contract first articulated in the 17th century by John Locke, the political philosopher. More significant today are the writings of Iris Marion Young. Though she did not address children, a lot of her arguments are very germane to the problem that we're discussing in relation to children. She argues that instead of a fictional contract, what's required is real participatory structures in which actual people, with their geographic, ethnic, gender and occupational differences, assert their perspectives on social issues that encourage the representation of these distinct voices. She argues that oppressed groups should have a guaranteed role in policy formation. This group representation implies institutional mechanisms and public resources supporting three activities: self-organisation to achieve collective empowerment, group analysis and group generation of policy proposals in institutionalised contexts where decision makers are obliged to show that their deliberations have taken group perspectives into account, and group veto power regarding specific policies that affect a group directly. She doesn't develop the implications of these proposals for children, but they can be so considered. The concept of an impact statement can be clearly, for example, seen in the second of these policy agenda. Young writes also of oppression, much more fully than anyone else had done at that time, and sees this as having 5 faces, all relevant to children. They are exploitation, marginalisation, powerlessness, cultural imperialism, and violence. Now, as I say, she doesn't discuss any of these in relation to children, but each of them is relevant in children's lives. Brief examples are the exploitation of young carers. There are about 250,000 in this country, 25,000 people under 9. Marginalisation of racially marked groups, powerlessness of all of those deprived of voting rights, cultural imperialism, common to those stereotyped as the other, and violence, institutional racism, child abuse, corporal punishment, and so on. Young offers us a partial characterisation of children only, but it's certainly in the late 70s, when the possibility of a convention was first being mooted, that there was no demand by children for a code of children's rights. The initiative came, I said earlier on in this lecture, from enlightened adults whose actions may be described somewhat ironically as paternalist. Adam Patka, who'd been chair of the UN Working Group on the Convention on the Rights of the Child, Pole, recollected at a conference in Jerusalem in 1990 that children needed additional human rights because they were weaker than adults. It's worthy of note that when Patka summarises the Convention, he quotes Article 12, and he refers then to the child's right to privacy in Article 16. But he ignores the basic freedoms in Articles 13 to 15, expression, thought, conscience, religion, association, peaceful assembly, which not only children but also adults lacked in the communist bloc, which had just come to an end when he spoke And I recall asking him a couple of years later, when we were revising text for publication, whether he'd like to change this, but he was steadfast in his refusal to do so. Of course, it's the articles following Article 12, the very ones missing from Patka's account, which point beyond participation towards citizenship. It's an interesting question why we empathise, so while we emphasise participation, which is vague and indeterminate, that a whole scholarship is built up trying to pour some content into it, but at the same time gloss over the very rights which we associate citizenship with. And more to the point, the freedoms most likely to be articulated by older children, at least those in the global north. So what I'm saying is that Article 12 is a beginning, perhaps the beginning of the end, but it's very far from the end. It's a reflection of a dominant adultism. It's a long way from democracy. Perhaps youth activism points the way. We saw an example of this earlier on in one of the other lectures when I talked about an organisation called Youth Liberation of Ann Arbor in Michigan. There were also judicial statements in that era as well, albeit isolated. A famous one was Justice Abe Fortas in Tinker, who supported the right of school children to protest the Vietnam War. Today, much engagement for democracy in parts of the world where it's totally absent stems from youth activism. But don't forget, not only from youth activism, we should never forget the importance of the work of Janusz Korczuk, who I've lectured on in both the previous two lectures. The man who ran progressive orphanages in Poland 100 years ago. He designed them to be just communities. He wrote a Declaration of Children's Rights. It was never published as such. I'm hoping to put it in as an appendix to the volume of these Hamlyn Lectures this year. And there are a number of rights that he puts into his convention, which are certainly not in the UN Convention. For example, the right to respect, the right to make mistakes, the right to be taken seriously. He was convinced that children were more capable than most adults think, and I think on that he was right. Now, as we move towards citizenship, let me quote to you from Patricia Williams. Many of you may have heard her. She gave the Youth Lectures a few years ago, and she talks about racism. So she's not talking about children, she's talking about racism, but she makes the interesting point, when women enter environments where men have only been talking to men, the conversation is bound to change. If blacks enter spaces where whites have been talking to other whites, the conversation is bound to become somewhat more encompassing. And I think there are important lessons here, including the lesson that if your children enter into decision-making processes where they've got something to offer, the deliberations, the discussions will change as a result of this. It's obvious, of course, that children will participate more effectively with proper adult support, and that's an issue which I discuss at some detail in the book version of these lectures, but I won't have a chance to talk about today. There are many examples of youth engagement for social change outside the confines of traditional politics, and I've mentioned a few of them to you already today. One that I always like to quote is the way in which youth were prominent in South Africa in the fight to remove apartheid. The Soweto riots, which initially targeted the imposition of teaching in Afrikaans, which was the language of their oppressors, was a catalyst for the demise, ultimately, of apartheid. Youth have taken leading roles in protests about war, about corruption, about censorship, about the undermining of democracy. For example, the Umbrella Revolution in Hong Kong recently hasn't got very far, and the role, which got even less far, that the youth played in the Arab Spring, which didn't last even as long as a typical spring lasts in this country. Political activism by the young then can pass unnoticed when it takes place away from adult society, in schools or more commonly in social media. Now, all of what I've been discussing for the last few moments transcends by far what the drafters of the Convention had in mind when Article 12 was being formulated. It's essentially the work of young citizens while their citizenship is being denied. It's a remarkable fact that neither the Convention nor any other human rights treaty recognises any right to citizenship. And just as remarkable as this is, it's hardly anywhere commented upon. They can have escaped the notice of almost everyone who's written in this area. Has always surprised me. Jaap Duk, the Dutch leading academic, it's about the only exception to this. The Convention does, it is true, stress in Article 7, that every child has the right to acquire a nationality. But nationality is, of course, an element of citizenship, but it's far from the only content. And so inevitably, I have to ask the question at this point, should we enfranchise children? One of the odd things about doing lectures like this is that you write something one day and the next day it happens. So some of this will have to be written in the past, I hope. But as many of you will know, there was a vote in favour of 16 and 17-year-olds having the right to vote on the referendum recently. And of course, they voted in the Scottish referendum as well. But the real question, I think, ought to be broadened beyond this. To what extent should children have the right to vote in all elections? Is there a case for enfranchisement? Should the vote be extended to all children? And if not, where should the line be drawn? In the majority of countries, the minimum age to be allowed to vote is 18. A generation ago, of course, it was 21. There's an impetus towards lowering the age to 16, as we saw this week and as we saw in the Scottish referendum on independence. Indeed, it was a manifesto commitment of the Liberal Democrats, if you remember them, in the year 2001, to lower the age of voting to 16. But the Electoral Commission rejected such a reform. In its view, 16-year-olds had insufficient social responsibility and emotional maturity. The Commission, in fact, feared that if the age at which people could vote were lowered, the percentage of people voting would actually decrease. It's certainly a very strange argument. That, of course, assumes nothing else changes. But a party pledged to promote the interests of the young might well encourage greater participation by those currently disadvantaged and disaffected. Widening the places, for example, in which votes can be cast. Opening polling booths in schools, in universities, in factories, would see greater participation. It's significant that Article 12 gives children the opportunity to be heard in judicial and administrative proceedings, but legislative proceedings are not included. It's common, of course, to put children's welfare first, and some people would say that's much more important than their citizenship, and I don't deny this. But to give the vote to young children would certainly be pointless if you didn't protect them from abuse. On the other hand, creating citizens might be one way of trying to tackle many of the other problems that concern children. Those who are critical of votes for children commonly cite the lack of competence as the reason. But competence is not the test. if it were, a substantial number of adults would lose their right to vote. About 95% probably. And anyway, when is someone competent enough to participate in democratic politics? What amounts to competence? Mill talked about it as political intelligence. When did you last see any of that? Dahl referred to it as an enlightenment. He argued that an 8-year-old child can hardly be enlightened enough to participate equally with adults in deciding on laws to be enforced by the government of the state. An extensive study of the American electorate assessed their knowledge by summarising the results of a large sample of surveys between 1940 and 1994. In total, 448 factual questions about institutions, processes, people and players were included, as well as domestic and foreign affairs. 43% of the questions were answered correctly. But should those who are particularly competent have perhaps more than one vote? There was a time when Oxbridge graduates did, even those who were not members of the Bullington Club. That was the case until 1948. John Stuart Mill supported this, even arguing that employers should have extra votes because they had lots of employees. If the test is pitched too high, even some MPs would not satisfy it. Examination of the Prime Minister might be interesting in relation to this. So why is 18 the standard minimum age? It is not stipulated because 18-year-olds have got insights which 17-year-olds lack. '18, of course, is the age of majority, though that, of course, is pretty arbitrary as well. It's not an inflexible rule. For example, you can marry at 16, but you can't keep a hamster till you're 18. One of my favourite examples. You can keep a wife for 2 years before you can keep a hamster. One country in which you can vote at a younger age than this country is North Korea. You get the vote at 17 in North Korea. And it hasn't rocked the boat there. But if we were to reduce it to 17, why not 16? And why not 15? And on it would go. Regression is infinite, has infinite potential. It seems the line has to be drawn somewhere. Or does it? What harm would be done to our polity or civil society if the franchise were extended to the whole population? We would be giving the vote to know-nothings. But there's nothing novel in that. And know-nothing Tories would, broadly speaking, cancel out know-nothing Labours. I don't imagine many 3-year-olds would exercise the vote. But it would be difficult to, short of the competence test, exclude them from it. Politics is about the art of the possible, so I'm not advocating that we do give the vote to everybody, at least not yet. But I can't see any arguments at all against lowering the age at which people can vote to 16. Well, that covers about a twelfth of the lecture.
Nobody's showing any signs of impatience.
I'll go on for a few more minutes anyway then. They just want me to go on in case I fall again. I've taken and spent a fair amount of time on that because I think it shows the way in which we can acknowledge the importance of the convention whilst needing to push beyond it, and push beyond it into genuine policy issues like enfranchising children. One of the other developments that's taken place of importance since the convention in 1989 has been the growth of neuroscience. We've begun to unwrap the mysteries of the human brain. This is, as you will all know, the most complicated mechanism known. We live in an age of unprecedented discoveries and challenges as regards this. A generation ago, we mapped the human genome and were promised all manner of progress. No shortage of enthusiasm greeted its earliest findings. We were told that there would soon be a genealizer in every doctor's surgery. The internet erupted with promises of ways of enhancing our lives. We were going to be able to improve our children's athletic performances, though this would have fallen foul, I suspect, of the sports authorities, like a banned drug. We were going to discover the best diet suited to our genome. We even promised that we could identify through DNA analysis whom we should marry. The same hype may well greet discoveries which emerge from the brain sciences. Hopefully not. Because from misunderstanding come false expectation and sadly exploitation of the vulnerable and the gullible. But the implications of neuroscience for children's rights cannot be overlooked. It has proved quite significant in the United States of America, where the Supreme Court got rid of the death penalty for those who committed crimes when under the age of 18, on the basis of the lesser development of the brain of impulsive young, I suppose thugs would be the best word of using it. Both cases that would be considered, that would have been the situation. Very briefly, what are the implications of neuroscience then for the kind of things I was talking about under Article 12? Letting children make decisions for themselves, letting children vote in elections. Is it a question of giving them their cake and depriving them of the cake and eating it as well at the same time? Is it inconsistent? Is there incoherence in an argument that says they're not mature enough to get the adult punishment for a crime, but they are adult enough to vote in an election, to participate in decision making? And one of the American Supreme Court justices actually picked this point up and said, how can we say that children can make decisions about abortion if they can't make life and death decisions about using a gun? I think the argument is not a sound one. I talk about it in great detail in what will be the book. Impulsive decisions are very different from ones which are thought out. And using a gun in a robbery is not thought out in the same way, I would think, as deciding who you're going to vote for in an election or making a decision when you terminate a pregnancy. I have to say that it is doubtful whether those who debated the convention in the 1980s had any knowledge of the existence of neuroscience, let alone whether it might impact on our understanding of adolescent behaviour. What neuroscience appears to be telling us at the moment is that our brains are not fully developed until about the age of 25, which might mean pushing up the age of criminality beyond 18, what it also is beginning to tell us is that our brains decline from about 45 onwards, which only gives us 20 years to keep them in prison. I can't see these kind of research findings being particularly influential, at least initially. And that leaves me with one or two other points that I just mentioned to you very quickly. Since I've mentioned the age of criminal responsibility, we've got to do something about changing that in this country. We are currently regarding as capable of committing crimes children who are barely out of primary school. In fact, they aren't out of primary school, they are 10. And if you take things like antisocial behaviour orders, they can be younger than that as well. We have an age of criminality in this country fixed at 10, which is internationally totally unacceptable. Almost the lowest one in Europe. I think Malta is lower. Indefensible that we retain it. It's also indefensible that we retain laws in this country which allow parents to hit children. There are now 47 countries in the world which have made it unlawful. The latest was Ireland, only last week. So it's getting closer to us. The defence of Tony Blair, for example, for our current state of the law, was that it was only a loving smack, which is a wonderful oxymoron, rather like the military intelligence that caused the wars that we're still talking about. Nor can we, I think, go on that for any kind of compromise. I think it's Canada which has the compromise that you can't hit a child until he's 2, and you can't hit him after he's 12, which gives you a fair window of opportunity, but conveys the message to parents that you can hit your children. It doesn't convey the message of doing it between different times. And our laws, which say that you can hit a child so long as you don't leave a mark, is only encouraging innovation and Lord knows what else before one does that. So I've given you a few of my ideas about a Magna Carta for children. I would suggest that our Magna Carta for children would start with the Convention and build on it. You don't want to reinvent that which has been done already, and a lot of it's been done quite well. But if you took each of the articles in the Convention in turn, you could improve each of them. Article 1 is the definition of a child, inconsistent with the preamble to the Convention. Article 2 deals with discrimination, but misses out certain areas of discrimination. The best interest article, Article 3, has caused huge amount of discussion both by academics and by courts, and again could be improved. References to family, to culture, to violence, all of which will be found in the Convention, all need to be smoothed out and spelled out rather better than they are at the moment. But we've gone quite a long way down the path of trying to put children onto the human stage as beings, as citizens, as members of society. And for that we must be very grateful. It's often said that you can judge a society by the way it treats its weakest members. I would suggest to you that if that is the test, we've done quite badly, but things are beginning to improve, and one would hope that they will improve a lot more in the near future. Thank you for listening to me. Yeah, sure. Wasn't that good?
I've never heard applause like that. Well, that was wonderful applause and richly deserved. And who's going to ask the first question? You've got to be brave. Oh, please.
Michael, I enjoyed that lecture a very great deal, and it was splendid also to see your own children here, no longer children. If you raise the age... Okay, thank you very much. If you raise the age of criminal responsibility and lower the voting age, then sooner or later you're going to be able to have children committing electoral offences without any redress. That's a slightly facetious point, but I'm trying to make the general point that although everybody accepts that children need more and more rights, and the age of criminal responsibility and the voting age are entirely arbitrary, surely there does come an age when children are too young to vote, perhaps when they're too young to read, and surely there does come an age when we must criminalise young people.
What's stay sitting down?
Yeah. They are, as you say, different questions, though they are related. And certainly public opinion would probably not support lowering the voting age any more than it would support raising the age of criminality. I think you were also involved in it because I saw you there. We both, I think, spent a day at the Bulger trial. Pretty sure you were there that day. And what was seen on that occasion really showed how ludicrous it was. It was a bit like some of the trials that used to take place of animals. You had these two boys, aged just about 11 by the time they were tried. They were 10 when they committed the crime. One of whom was most surprised that James Bulger wasn't coming back because he put it in Charlie and the Chocolate Factory, the child does come back. Now, if that is sufficient understanding to be able to commit a crime, I don't know where we are. The people who should have been on trial in the Bulger case were the 38 people at least who watched these two boys drag this toddler through the streets of Liverpool and ill-treat him on the way. I've often said, and it's probably true, that if James Bulger had been a dog, he'd be alive today. Because he would have been removed from the... there's little point using penal sanctions against young children. We tried to raise the age to 14 50 years ago nearly. It was only because of a change of government, a move from Labour to Conservative in 69 or 70, I think it was, that didn't happen. I can't see any argument that can really be used against raising the age at least to 12, if not to 14. And the UN Committee on the Rights of the Child has advocated that 12 should be the lowest age. What I think is striking is if you read up cases from other countries, there's a case from Norway where two boys killed a little girl of about 5. And they were not treated punitively at all. What is even more remarkable is that in the 1870s, there was a case with facts almost identical to the Bulger case. And the boys, if you listen to the judge giving his homily at the end of the case, he's actually more sympathetic to the boys than the judge was in the Bulger case. The boys in the 1870s case were sent to Canada. Very serious punishment. But what is interesting is that because the goal was rehabilitation, one of those boys ended up as the mayor of the town where he was sent. And that's pretty remarkable. That answers half your question. I think you're going to fall off a chair, really.
Well, can we have the next question? There's a gentleman in the third row with a tie on. Could you say who you are and what connection you have with the subject, other than being present?
My name's Ian Ford. I'm an independent social worker and also working as an education welfare officer in a London authority. You spoke about the social contract in your lecture, and we've spoken about children's rights, and I wonder what your view is in terms of concomitant responsibilities, whether that would be relevant in terms of the age of responsibility. This is particularly relevant for my job, where we are prosecuting parents of 16-year-olds who choose not to go to school, and the children are actually bigger than their parents. And I just wonder how one would then combine rights and responsibilities under your proposed new regime.
Thank you very much.
I've got a section actually in the book on responsibilities. I can let you have, you might be interested in, a cartoon drawn up in South Africa which puts rights and responsibilities together and does it very well. It shows that for each right we give children, there are responsibilities that they get. So, for example, one right that children have is the right to a good education. The concomitant or correlative responsibility is that they have a responsibility to respect teachers. And I can see that quite sensibly. Or they've got a right to food, but they've also got a responsibility not to waste food. And it goes through the rights and puts responsibilities to each of them. And I certainly do believe that.
Thank you. Well, I have one more question. Who's ready to ask the last question? Thank you very much. There's somebody right at the back there.
My name's Jeff Corrie. Hello. I'm a retired social worker and currently a trustee of the National Working Group on Child Exploitation. My question, Michael, is do you think that a Magna Carta for children should start with those children who are subject to another oxymoron, namely in care?
Now, I don't see any reason why it should start with that. What I start with, but I obviously couldn't develop it in any detail here today, is a lengthy preamble which describes why children have got rights, looks to things like dignity, respect, vulnerability, equality, autonomy, and so on, and draws out of that a case for children's rights, a case for taking children's rights seriously, which I've written about on many occasions. There would doubtless be some element dealing with children in care, though I haven't put one in, because I visualise my Magna Carta being about 250 pages long and not an encyclopedia. And lots of things have had to be left out. But I wouldn't start with it. You certainly could put something in. But I'm not sure that it's quite the oxymoron that you're describing. Anyway. Yeah. Yes, that's right.
Well, thank you, ladies and gentlemen, very much indeed. I think you've already shown that we've heard an exceptional lecture, and I've certainly found it totally fascinating, as you have done. And you mentioned kindly the Gillick case, which I was involved in as a High Court judge a long time ago. In the House of Lords, I thought there was a remarkable judgment by that great judge, Leslie Scarman. And what he said was that with the children, they develop, and their rights deserve to be taken into account as they mature. And I wonder if one day you might like to consider that is the answer, because it seems to me the two themes you were talking about, which we've had our attention drawn to, one is the question of responsibility for crimes, and the other is rights, which children, if they have them, should be able to exercise. And I think this way is illustrated in Lord Scarman's judgment of the rights being developed on questions of what they should be allowed to influence and what they should not, seem to be always very, very wise. Now, sitting in that wheelchair, Michael, is your grandchild. I think that is rather remarkable in itself, because how good, from that child's point of view, that she should have been able to take in what you were saying today. And I think when she's a little bit older, she will realize the privilege that she's undergone this evening as a result of your lecture. And I can only say that while you were talking, there wasn't a murmur. But immediately somebody else raised a question, I noticed a degree of unhappiness. And I think it just shows that your genes are traveling successfully down 2 generations, because that child is very perceptive indeed. So, ladies and gentlemen, thank you very much for being such a lovely audience.
Thank you.